Hello again, everyone. Welcome to Washington Gun Law TV. I'm Washington Gun Law President William Kirk. Thanks for joining us. It is December 31st, 2023. It is the 365th day of the year, and why not end the year exactly the way all other 364 days prior to that went, which is the citizens of California getting absolutely screwed by the cabal that is the Ninth Circuit. Don't believe me? Well, we're going to talk about an emergency stay that was just granted on a case that we have geeked out about before, and what it really means is that tomorrow, California, when you wake up, well, your life is going to be a lot different. Don't believe me? We'll connect the dots for you here in just a moment. So today, let's spend a few minutes. Let's send 2023 out in style and talk about how Californians will wake up tomorrow to no Second Amendment rights. Okay, California, we're talking about you again. Shout out to our first ever California subscriber. Of course, that is Philip P., who's been spreading the gospel of Washington gun law ever since I had a hairdo that looked like this. Okay, we are talking about the case of Reno May v. Bonta. We have geeked out on that case before. It is a challenge to provisions of California Senate Bill 2, which essentially would have turned the entire state of California into one gigantic sensitive place. Translation, it does not matter if you are licensed. If you have actually been fortunate enough to get a concealed carry license in the state of California, one, congratulations, you're like a unicorn that poops ice cream. But it doesn't matter because effective tomorrow, literally every single place in the state of California is a sensitive place. And you sit there and you go, well, wait a second. I heard that there was a big injunction that the United States District Court for the Central District of California had enjoined literally the entire law. They had. Why? Well, because they followed the Constitution. But California, you should know this all too well, there is the Ninth Circuit sitting above. And the cabal that is the Ninth Circuit has once again stuck it to the citizens of California. There is a 1.5-page order which now stays that injunction. So, put other words, tomorrow, all provisions of Senate Bill 2, as it relates to all of these sensitive places, California, is going into effect. The order of the Ninth Circuit, all 1.5 glorious pages of it, reads as follows. The request for an administrative stay contained within appellant's motion for stay pending appeal is granted. The motion for stay pending appeal and the supplements, responses, and replies thereto are otherwise referred to the panel assigned to decide the merits of these appeals. The District Court's preliminary injunction issued on December 20th, 2023 is temporarily stayed pending resolution of the motion for a stay pending appeal by the merits panel. In granting an administrative stay, we do not intend to constrain the merits panel consideration of the merits of these appeals in any way. The existing briefing schedule remains in effect. This, folks, is an administrative stay issued in the wee hours of the afternoon, right before a holiday weekend, that basically says, well, you know what, I know the court enjoined it, but what we're going to actually do is we are going to allow the law to go into effect, and then we'll let the Ninth Circuit kind of figure it all out. And you all know, because you've seen this before, you've seen it in Miller, you've seen it in Duncan, you've seen it time and time again, the fix is in. So, what does that mean to you, California, when you wake up tomorrow, January 1st, 2024? Well, it means that no matter how well-trained you are, no matter how lawful you are, no matter how responsible you are, and no matter whether you actually possess a California concealed carry permit, you will not be able to carry a firearm into any of these locations. Hospitals, public transportation, liquor stores or restaurants that serve alcohol, parks, stadiums, libraries, museums, banks, casinos and other gambling institutions, and private property. And that last one is absolutely the most offensive. So unless the private property owner says, oh, all guns are welcome here, then you must presume that that also is a gun-free zone. Essentially, the state of California is going to step in on all private property owners and tell them that they know what's best on how they should manage their property. Now, California, you have a big decision to make here because, yeah, the fix is in. And if you think that the Ninth Circuit is going to fix this problem, absolutely, positively not. They're going to shove this down your throat. So what are you going to do about it? Well, might I suggest you take a playbook out of a state that also suffers from the same type of tyrannical state government. And of course, I'm talking about all my friends out there in Illinois. Because as you may be aware, after Illinois turned an innocuous piece of insurance legislation into an outright assault weapon ban in less than 72 hours, and then required all of their citizens who had grandfathered firearms to register them with a state gun registry. Let me say that again. Register them with a state gun registry. And the deadline for that is midnight tonight. And if you want to know what the state of Illinois residents have told their state government, it is this, right here. Because right now, as I'm crunching the numbers, the compliance rate with this law in the state of Illinois is somewhere between 0.63% and maybe as high as 5.5%. So, my question to you is tomorrow when you wake up, what are you going to do? Are you going to actually comply with this law? Or are you going to do what Illinois is doing? And let me remind you that there is case law out there that absolutely positively states that when it comes to an inalienable right, we almost have a moral obligation to violate laws that we know to be unconstitutional. What am I talking about? Well, I'm talking about the United States Supreme Court case of Shuttlesworth versus City of Birmingham in 1969. You see, that case involved an African-American gentleman who had the audacity to stand on a street corner and profess his views to a group of people. When he was ordered to disperse from the sidewalk, and he just merely asked the question, what, I'm not allowed to stand on a public sidewalk, he was arrested because he had not obtained a prior permit for him to hold that event on the sidewalk, okay? Now, obviously, there were significant racial overtones to this entire case. Upon overturning his conviction, the United States Supreme Court, in a free speech First Amendment case, stated the following. In the free speech context, an individual faced with such an unconstitutional licensing law may ignore it and engage with impunity in the exercise of the right of free expression for which the law purports to require a license. Now, that is in the free speech context, okay, the First Amendment context. And one of the things that all of those who favor civilian disarmament always say is that, well, no constitutional right is limitless. There may be a little bit of legal truth to that. In the First Amendment, there is a litany of case law that suggests there are some reasonable limitations that can be placed on the First Amendment. However, there's no other amendment that happens to contain the language shall not be infringed. So, you all have a very, very difficult decision to make. I do not know whether law enforcement in some jurisdictions intends on enforcing this. I can guarantee you in other parts of California, law enforcement will feverishly support and enforce this law. Okay, so the bill once again is Senate Bill 2. The case once again is Reno May v. Bonta. We'll go ahead and link up this incredibly short order from the Ninth Circuit. Could have scribbled this thing on a cocktail napkin. We'll link it up if you got the 10 seconds to geek out on it for yourself. Listen, if you got any other questions about this or anything else related to what's left of our Second Amendment rights, you guys should know how to get a hold of Washington Gun Law by now. If you don't, that's okay. That information's right down there in the description box. Now, in the meantime, let's everyone remember that part of being a lawful and responsible gun owner is to know what the law is in every situation and how it applies to you in any instance that you may find yourself. Until next time, Happy New Year. Thanks for watching and stay safe.